So it seems like Congress is about to begin subpoenaing members of Congress. What are the legal implications of that? What are the practical implications? Let's talk about it. Because getting to the bottom of who is responsible for the insurrection, like justice, matters. Hey all, Glenn Kirshner here. So it looks like Congress will begin to subpoena some of its own as part of the House Select Committee's investigation into the January 6th attack on the Capitol. And I'd like to use as a starting point for a discussion on this topic an article in The Atlantic that was written by a good friend of mine, Kim Wehle. Kim is a former federal prosecutor, she's a law professor, and she's a constitutional scholar. And she just wrote an article on this very topic. And here's the headline in The Atlantic, or the title. A case for subpoenaing members of Congress to testify on the January 6th insurrection. And the article begins, by any logical measure, the question of whether members of the House GOP knew about or were involved in the events of January 6th falls squarely within the legitimate scope of Nancy Pelosi's investigatory select committee. And Pelosi seems eager to follow through. Last week, the House Speaker signaled that the committee would soon be focusing on sitting members of Congress who, in her words, participated in the big lie. The next step may well be a first for the country, subpoenas to current members of Congress issued by a committee of Congress. The Select Committee's chair, Democratic Representative Benny G. Thompson of Mississippi, has said that he has no reluctance to subpoena members of Congress whose testimony is germane to the mission of the Select Committee if they refuse to cooperate voluntarily. And Thompson announced this week that investigators would seek phone records from telecommunications companies relating to the attack, including those of members of Congress. Will these subpoenas withstand legal scrutiny? There's no established historical or legal precedent regarding congressional power to enforce subpoenas against members of Congress, but if the bipartisan committee has to defend the subpoenas in federal court, it could make a strong argument that the Constitution allows a court to order compliance. So I tend to agree with Professor Wehle that members of Congress can be subpoenaed to appear before congressional committees if their testimony is relevant to the issue being investigated by Congress. So let's assume that to be true. Let's assume the Select Committee can lawfully, can constitutionally subpoena its own to testify. What happens when a guy like Jim Jordan gets a subpoena? We know he has relevant information about the attack on the Capitol. How do we know that? Did you see him trying to answer questions posed by a reporter? Representative Jordan, did you talk to the president on the phone on January 6th during the attack on the Capitol? And Jim Jordan's response, which I think I can quote nearly verbatim, went something like, hamina. It's not hard to spot a liar. So what happens when a guy like Jim Jordan gets his subpoena to appear before the House Select Committee? Well, he could just not show up. He could just fail to comply with a lawfully issued congressional subpoena. And if that's the path he took, there are three ways to try to force him to testify: criminal contempt, civil enforcement, and the inherent power of Congress to enforce its own subpoenas. But I'm not going to talk about those three enforcement mechanisms now. I've talked about them in earlier videos. I want to move past that and talk about the practical implications. What happens when and if a Jim Jordan is sitting there in front of the House Select Committee, and he is about to be questioned about his knowledge and possible involvement in the January 6th attack on the Capitol. So that's when it gets real for a guy like Jim Jordan, when the questions start to come about what he knew and what he did in connection with the insurrection. And Jim Jordan could do one of two things at that point. He could either answer the questions, or he could invoke his Fifth Amendment right against self-incrimination. He could plead the Fifth. Of course, if he pled the Fifth, he'd be virtually announcing to the world that he committed crimes, although I think the world already has a pretty good hunch. And he would also be asserting that if he were made to testify, he would be incriminating himself. He would be telling everyone about the crimes he committed. So let's assume a Jim Jordan pleads the Fifth, refuses to testify. The ball is then in Congress's court. Congress has a decision to make. Do they just accept the invocation of the Fifth Amendment privilege against self-incrimination and dismiss the witness, because a guy like Jim Jordan probably has a legitimate Fifth Amendment privilege against self-incrimination, given what we know about what he did? Or does Congress decide to grant him immunity and force him to testify, compel him to testify about his own possible criminal conduct? That is a difficult decision, and it has some pretty serious implications. What's the downside of granting a witness immunity? Well, the downside is that it may make it much harder to prosecute that witness for the crimes he committed after he's been forced, under a grant of immunity, to testify about his crimes before Congress. Remember this guy, Oliver North? So Oliver North committed crimes as part of the Iran-Contra affair in the late 80s, and then he was called before Congress as a witness. And he was granted immunity, and he was forced to testify about his own crimes. What happened after that? He ended up being indicted, being prosecuted, and being convicted for committing 3 felony offenses. But on appeal, his conviction was reversed. It was thrown out. Why? Because Congress had immunized him and forced him to testify about his own crimes publicly, and there was some risk, some chance, some likelihood that some of that information made its way into the criminal prosecution, so ultimately his testimony was used against him. And the appellate court threw out those 3 felony convictions, and he was never tried again. So he was a convicted felon. The appellate court overturned his conviction. After that, he was a failed politician and briefly the president of the NRA. That's Oliver North. But that highlights how Congress's decision about whether to grant somebody like a Jim Jordan immunity and forcing him to testify about his own misconduct can have real consequences and can make it more difficult moving forward to then bring criminal charges against a Jim Jordan or anybody else who might have criminal responsibility for any piece of the insurrection. And boy, do we want to retain our ability to charge criminally in a court of law every single person who has any criminal liability, responsibility for the attack on our democracy on January 6th. Because justice matters. Friends, as always, thank you for tuning into these daily videos. You can also get Justice Matters in podcast format, audio only, and you can go wherever you usually get your podcasts. As always, friends, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.